This is Ross Runkel. I'm here to tell you about a case pending in the Supreme Court going to be argued on January 17 called Encino Motorcars against Navarro. And I'm going to try to take this extraordinarily boring case and make it somewhat interesting for you. The question is whether service advisors who work at car dealerships are entitled to overtime under the Fair Labor Standards Act. And there's about 100,000 of these service advisors around the country. So what do? You know, when you take your car in, you got something wrong, the person you're going to be talking to right away is your service advisor. You tell them your story, they'll look at your car, they'll recommend maybe some parts that need to be changed or something needs to be fixed. And so they're selling you the service to get your car fixed. Now, back in 1966, Congress decided that they're going to carve out a little exception for car dealerships so they do not have to pay overtime to certain employees. And here's the definition, in quotes: any salesman, partsman, or mechanic primarily engaged in selling or servicing automobiles. Okay, so that's the question before the courts, whether these service advisors fit that definition. Now the courts already had this case in 2016, and they looked at it and saw that the Department of Labor had been interpreting that statute and flipping and flopping back and forth. And the last time they flip-flopped in 2011, the court said, look, you guys didn't really explain why you made this recent change, so basically the courts are going to have to ignore what the Department of Labor was saying. So they kicked the case back to the Ninth Circuit. The Ninth Circuit made a decision. That got kicked back up to the Supreme Court, and that's where we are today. So what are the employees arguing? Okay, their argument is very simple. They're saying, look, our people do not sell cars and they do not service cars, and so they don't fit within this statutory definition. Dealerships, on the other hand, are making also a very simple argument. They take those statutory words and they leave out a few as they go along, and they're saying, look, these people are salesmen that are primarily engaged in servicing automobiles. So both sides have a pretty good argument. And the briefing will show you that there's a lot of very complex arguments about how you interpret statutes. They're using a lot of Latin words and a lot of rules of construction. And if you want to read all about that, those briefs are, in fact, on the website that the U.S. Supreme Court maintains. Now, in the 2016 decision, we have some hints about how this is going to come out. Justice Thomas and Alito both committed themselves by saying that the service advisors are not entitled to overtime because, and this is basically the employer's argument, they are salesmen primarily engaged in servicing automobiles. At the same time, Justice Ginsburg and Sotomayor hinted, they didn't really say this, but they were hinting that these folks are entitled to overtime because, hey, they don't personally sell cars, they don't personally service cars, and so they don't fit the definition. So that's the exciting case, argued on the 17th, and we'll expect a decision sometime in the spring of 2018. Thank you for watching.